Welcome, everyone, to this Saturday, January 16th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. We've been talking about, since we started on the network here with the show about past a year and a half ago, we're heading on 2 years now, so we got quite a bit of content, probably that hasn't even been released that you're not even aware of. But, you know, I've been switching gears from really debtor-creditor relationships and been switching everything into trust, and from here on in, I'm 100% geared towards that everything happening today is a trust. If you think you're going to the grocery store and buying your groceries with Federal Reserve debt instruments, you're really forming a trust and you don't even know it. If you're going to the gas station buying gas, you think you're purchasing gas with debtor-creditor relationship or fiat currency, whatever you want to call it, but it's really a trust. The fact today that there is no lawful money, then there is no money to make any consideration or exchange any value for consideration to complete any kind of contract. So therefore, there cannot be any contracts. And if there are no contracts, then what is everything? Well, the trust came in and filled the void because it's the mechanism that's been used all this time, and it's never really been revealed that everything happening today is really a trust. You are forming a trust with everything and you're not realizing it. So I am totally taking my thinking, my attitude, and a whole paradigm shift 180 degrees the other way. And I am, from this point on, as I have been since November, when we came out with NTT as New Trust Technology, I'm switching my mind around from that old debtor-creditor relationship thinking to solely thinking trust. And all those people that are listening to me, I hope you do the same thing, that you do a paradigm shift as well as I did, that you would start looking at things in trust eyes. Think of everything that you're doing, especially what you're putting your signature to, is that you're creating a trust. And on this show, we've been talking about the elements necessary for the trust, the rule of the signatures, the rule of the forms, the method of formation of a trust, the very basics, because if you don't know or understand that they are forming a trust, that does not negate the fact that if everything is there to form a trust that the law will recognize, then there is a trust. But that's the surprising thing, the really amazing thing, that none of us really have to know or understand that a trust is being formed, but yet there is a trust. And that expression of the trust, once you know and understand and you take it into their public realms, now you can operate both in the private and the public, and if you have both sides of the ledger, you're in control of both sides of the ledger. You're running the whole show. Everybody talks, we're running the whole show, but they never really realize how. Well, they're doing it through trust. We are really moving titles in trust. I was thinking about changing the name of the show, Money, Banking, and Trust by Moving Titles in Commerce. I was thinking of changing the name from Moving Titles in Commerce to really Moving Titles in Trust, because that's really what we're doing. We're really moving titles in trust that is functioning as commerce. Functioning as commerce. We're moving titles in trust functioning as commerce. Because really, there cannot even be any commerce today, because if there's no lawful money, nobody can complete any contracts, exchanges for any kind of goods or services that you would give me for any kind of product. So then, what is functioning as commerce? It's got to be a trust. Got to be a trust. So trusts are functioning as commerce. There is no debtor-creditor relationship really in Oz. It's all trust being disguised as debtor-creditor, and that's functioning as commerce. Really today, nothing that you have has any value. Now, how can I say that? Because if there's no money, what is the value of the money then? Zero. No value. Well, if money's the standard that we value everything with, and money has a zero value, then what is the value of your car or your house or your cup or the clothes on your back or the money in your account in the bank? What is it worth if everything has zero value to measure it with? What is the yardstick that we measure the product value, what it's worth. If that's the dollar, and the dollar is zero because it has no value, what is everything worth? Nothing. Zero. It all has no value. Everything is valueless. So how do we do any kind of contract? Can't. We don't even have leasehold relationships where we're making any kind of payments or any kind of thing that requires some kind of monetary value to be exchanged. It cannot be that relationship. So really, if you check through all the relationships, whether it be fiduciary or agency or debtor creditor or others, if they're based on leaseholds or whatever, if they're based on some kind of exchange of value, then there is nothing to value to exchange, then you can check that one relationship right out of the block because it doesn't exist today. And what is taking its place? Trust. Today, everything is trust. Now, we've been going over the Gilbert's Law Summary book, which is the statute and code version of trust. And it's the black edition. I mean, by black edition, it's the one that they're operating by, which is opposite the one we want to be operating by, which is private trust, which is the white. But if I teach you what the black is, you will know the white by sight. Because that's how you distinguish. You have comparisons. If somebody says that's black, and then when you see something that's opposite, you're going to know that's going to be the white. And that's what we've been doing. We've been studying the Gilbert's Law Summary, Trust, Edward C. Halbach Jr. I think it's the 13th edition there, but it's the 2008 copyright edition. That's what we've been studying to show the examples of how trusts are operating in their statutory realm. Now keep in mind, those are statutory trusts. And the trust that I'm talking about, the private trust, that's my Declaration of Independence or my Bible of 1776. And that's the trust, that's the master trust. And all other trusts are drawn against that, and those are all sub-trusts. There's only one master trust, all the rest are sub-trusts. Whether it be that City Key Trust, or whether it be the Foreign Situs Trust, or whether it's the Constitution, which is another trust, sub-trust. These are all sub-trusts drawn against that Master One Declaration of Independence that this founding fathers formed this country by, that I was given to me by God, unalienable, which are non-transferable rights, period. No modern view, no nothing. But you see, that old view has been put into trust because the common law, America, the old the Declaration of Independence has all been put into trust, and it's kind of like a circle. Everything started out was in the circle, but then they took the money out, and the trust rushed in, and that divided the line right down the middle in the circle, and half went to the right on the Republic side, where the common law and the substantive rights of the real man are, where the real assets are, and it's kind of like the ledger sheet. Assets on the right, the plus, and on the left of the line, then everything went into hiding because the line hid everything. Then the left side was the liabilities, the public side, the statutes and codes, the false money, and everything that's happening today under the colorable disguise of being the truth, which is all lies. And that's what's happening today. The trust divided the titles, because before that we had a perfect title. We had a perfect America. The trust, when we took the money out, divided it. And now our perfect America is held in secret. And that secret's in chambers. We want to hold the substantive rights of the real man, and that's where we want to access the real rights of the real man, and that's where the trust operates in equity. The equity side of the court in chambers. So a brief description of what we've been talking about. But all those of you who've been listening and following with me, we've all been coming down to that path, and I've announced before about the Moving Titles and Commerce Workshop. Well, that day has finally arrived, because this Saturday, January 16th, is the formal announcement of Moving Titles and Commerce Workshop. Now, this is with a new remedy through NTT as New Trust Technology, utilizing the Moving Titles and Commerce platform. And at present, the website is still under construction, and we are making an effort to grant you an entire spectrum of knowledge and trust as soon as possible. But at this point, we can provide you with information regarding the Moving Titles and Commerce Workshop utilizing NTT as New Trust Technology. And the emphasis of our site is on trusts and how they apply as a new revolutionary remedy. And this topic is certainly of interest to you, then you will check back later on this site for any updates. So, in the meantime, you can reach me at a new email address, which is Christian@movingtitles.com. Christian@movingtitles.com. And the website is up. And that website is movingtitles.com. If you go on the internet and you punch in on your browser movingtitles.com, you will get the one-page site that we have up so far explaining the Moving Titles and Commerce Workshop. So we are looking forward to hearing from you at that email address. And if you are not familiar with NTT and the Moving Title and Commerce platform, and you first contact us is really through the online website, we'd like to hear from you. So please let us know what your needs are and your questions are, and I'll be more than happy to answer them. But in brief, this is the formal announcement of Moving Titles and Commerce Workshop, which is a private workshop with a new remedy through NTT as New Trust Technology. And I've been speaking about Moving Titles platform on the show here at Money, Banking, and Trust by Moving Titles and Commerce for well over a year now, going on 2 years. And there have been many requests for further education on this topic, and we finally reached a point in time for an expanded understanding of the Moving Titles platform, including the explosive new remedy technology NTT as New Trust Technology. So I'm very pleased to announce the workshop, which is a quantum leap in technology. And this will be a workshop entitled Moving Titles and Commerce Workshop, as a workshop platform for building the revolutionary technology NTT as New Trust Technology. So again, what is Moving Titles platform? So in order to help people understand this confusing A through Z concepts out there today in this arena, I've come up with a simplified way of understanding it all, and a simplified way of looking at everything as a title in the public that represents the real thing in the private. And really both private and public have to work simultaneously together, because that's just really the way they set the system up. And you are not going to do without one side or the other. You have to utilize both sides. It's just the way that it's designed until you can merge the titles and take the dividing line down. So this represents the real thing in the private. That title is moved through an understanding of the technology that is used to move the title from one account to another, because that's what I'm looking at everything as an account, moving it from one account to another by a title. And this technology recognition is the Moving Titles platform. So what is NTT as New Trust Technology? So ever since I started the show, I've been studying trust, because trust is one of the words in the main title of the show. So while through studying trust, I've recognized the powerful secret implementation of the trust and its use, really. So the result of this study has emerged the revolutionary technology NTT as New Trust Technology, because that's what NTT stands for, New Trust Technology. Trusts have been around for a long time, since early, I think they were created on 1300s, 1400s, early, right in there. So trusts have been around for a long time. The recognition of trust as a straw man is relatively new, though. But in particular, the applications of the straw man trust in terminating the straw man trust, along with claiming the disbursements of all the huge assets held within the trust account, is a quantum leap in technology. Also, how trusts are used to enslave those who do not know or understand trust are deceiving the people into volunteering as slaves by the lack of understanding. The secret is, as I keep mentioning, that in a trust, nobody needs to know or understand that a trust is being formed. That's the truly amazing thing. This is how they're hypothecating you, how they're getting you to pledge. So knowing who you are is not being a secured party creditor through a debtor-creditor relationship, but only first through a trust relationship as grantor. It is knowing who you are as grantor. It's not knowing that I'm the real man on the land. It's got nothing to do with that. It has to do everything with knowing your first part is that you're grantor. This is the revolutionary concept. And we need to know and understand a trust in order to act in expressing and claiming a trust by proving a trust. And then we'll go ahead to the next level and learn how to administer the trust so we don't fall back into a dishonor or fall back into losing our assets again all over. So if we don't, we will be right back in volunteering into slavery by commingling the private trust with the public again. And we don't want to do that. So the Moving Titles and Commerce Workshop will be a work in progress where we together address these issues. And people attending the Moving Titles and Commerce Workshop will assemble our own documents, word by word, line by line, paragraph by paragraph, so they know and understand them. It is a workshop where they work and have access to details, more in-depth information, guidance through me with my knowledge and my understanding, and we will really learn together. So now, pricing. This relationship with myself and Moving Titles and Commerce Workshop is not free. To join this private workshop study group and have access to me is $299 per workshop. That is $299 per workshop, per person. Or you can pay for 2 successive workshops at the special rate of $249 price per workshop. Or that's $498 total for 2. That's a savings of $100 for 2 successive workshops. Now, each workshop includes your World Wide Web access through a webinar-style desktop access by computer. Now, that's a must. And your phone access into each workshop session for 2 hours per session. And there are 2 sessions per week. And there are 5 weeks to the total. And that total is going to be 20 hours. So you get 20 hours for that price. The price will include access to all past show recordings recorded for personal use and study. Registration is required. And the payment method will be released along with the start date and the time here sometime in January. And tentatively it's set for Mondays and Thursdays at 10 to 12 p.m. Eastern Time. And you must order the Gilbert Law Summaries on Trust by Halbach Jr., copyright 2008 by Thompson West, and it's approximately $28. And you also need to get Black's Law 8th edition, and I understand there's a 9th edition out there also. You need that, and you also need a UCC with the official comments. Must have the official comments. So these books are in addition to the workshop priced, and you must order them separately. And you must register an application. You must request an application from me at NTT registration at movingtitles.com. You must request a registration application from me at this email address, NTT registration, all one word, NTT registration at movingtitles.com. So in addition to the Moving Titles and Commerce Workshop, everyone has access to my show here on Saturday, and which I also have a show on Tuesday, and also have one on Wednesday. And these are free. And this show can be accessed The Saturday show can be accessed at therealpublicradio.net. But if you want to ask questions, you have to dial in on the landline, which is 712-432-8773, and the PIN access number is 179441#, to get into the Access Money Banking and Trust by Moving Titles and Commerce, so you can ask questions. So again, my email address for general questions is christian@movingtitles.com, and all my other email addresses work also.
630 area code. State your first name, where you're calling from, please. 630 area code.
This is Stan. Can you hear me?
Yes, Stan. Where are you at?
I'm in Chicago.
Good to have you. Welcome.
Thanks. Hey, Christian, I've been listening to you for only about the last 2 months now, but I've been the creditor-debtor stuff since about April. I just had some beginner questions. How is it that I don't understand the interface between the public and the private. If HJR 192 and Public Law 7310 and all that said that they would pay dollar for dollar, why don't they do that on the public side for us? You know what I'm saying?
Yeah, a while back on one of the shows I was talking about discharge versus set-off. And since we have two different realms now, we'd like to have a starting point, because each side is the mirror image or the reverse of the other side.
Mm-hmm.
So if we have discharge on one side, we have to have set-off on the other, because they're opposites and they're the antithesis of one another. They're the mirror image. They're the reverse. And my question was, before I wasn't quite thinking, and it comes right back down to House Joint Resolution, where do we start? Because if we called set-off on one side, and then the opposite of that has to be the opposite of set-off, which would be discharge, now the question is, which side do they fit on? And I wasn't thinking right at the time, but there was a starting point. Once we got a starting point, then we can say, okay, if that one is on one side, then the opposite of that has to be on the other side. Discharge is on the public side, and that's per House Joint Resolution 192. So that sets the discharge, what side discharge is on. So the opposite of that has to be on the other side, which is set off. So there's the two mirror images. And you have to understand what House Joint Resolution was really for. It was for creating a debt system, which was really a perfect way of establishing an unlimited amount of money due to a fiat debt currency, because you had the ability to raise unlimited funds with debt currency to get you through any national crisis or emergency. But here was the thing. There was a safety valve to that, because if you keep pumping up the debt, you're paying debt upon debt with debt with debt, and the debt just keeps mounting up, and eventually every system in history that has had a fiat currency system has collapsed. There's not one country that has ever sustained any length of time that has not collapsed in history. So what we did was, in this country, we designed a safety valve, and that safety valve was the opposite side, which was the set-off, because the set-off was used to relieve the pressure and bring the debt down and manage it within reasonable levels to balance it. Set-off balance the discharge on the other side of the pumping up of the debt to get us through any kind of emergencies. So that was...
And I'd like to... Forgive me. I wanted to add a little... insight into that. I have something that we have in our Da Vinci Code dictionary. As I said, I'm putting a lot of the legal sleaze in there to help people. We're putting the whole enchilada in there. And, excuse me, I have a quote from Edward Mandelhouse, which is fitting for Stan's question and your elaboration. And it goes like this, under Edward Mandelhouse. The banking ambassador had this to say in a private meeting, let me cough. Had this to say in a private meeting with Woodrow Wilson, the United States president, 1913-1921, President of the United States British Corporation in a box. Very soon, this is what Mandel House said, very soon, every American, very soon, okay, that was prior to 1933, very soon, every American will be required to register their biological property in a national system designed to keep track of the people. And it will all operate under the ancient, very ancient system of pledging. Pledging. Do you pledge allegiance, ladies and gentlemen? By such methodology, we can compel the people to submit to our agenda, which will affect our security. They need a hostage as a chargeback. That's the birth certificate for the fiat paper currency. Every American will be forced to register or suffer being able to work, suffer not being able to work, and earn a living. They will be our chattel, and we will hold the security interest over them, forever, by operation of the law merchant, under the scheme of secured transactions. From now on, all Americans, by unknowingly or unwittingly, having a delivery, the bills of lading, the birth certificates, when your mother was in labor unloading on the doctor, the one that had the power to tear, based on information, delivering the bills of lading to us, and will cause them to be rendered bankrupt, insolvent, should we say idiots, forever, forever to remain economic slaves through taxation, secured by their pledges. They will be stripped of their rights as debtors, and given a commercial value designed to make us a profit, slave labor, peonage, while they will be none the wiser. For not one man in a million could ever figure out our plans, but we did. And if by accident one or two should ever figure it out, we have in our arsenal plausible deniability, and we can kill them. After all, and they have, this is the only logical way to fund government, right, from your perspective, by floating liens and debts to the registrants in the form of benefits and privileges. You want benefits? Remember Kennedy? He says, ask not what your country can do for you, but what you can do for your country. Don't. Whoever gets the benefit is the slave. This will inevitably reap to us huge profits beyond our wildest expectations and leave every American a contributor to this fraud, which we call social insurance. Socialist communism, Fabian fascism. Without realizing it, every American will insure us, pledge allegiance, for any loss we may incur. And in this manner, every American will unknowingly be our servant or slave, however begrudgingly. The people will become helpless and without any hope for their own redemption, and we will employ the high office of the president of our dummy corporation to foment this plot against America. And that is in our Real Da Vinci Code Dictionary, ladies and gentlemen. Go to the urgent tab if you want a copy. Christian?
Yeah, thanks, Desert. Yeah. All that is really under debtor-creditor, though, and I don't have to operate under debtor-creditor. I can operate on trust and stay in the private. So
there you go. The secret.
Yep. I hope that answered your question.
Well, yeah, somewhat. It's not clear yet, but I'm sure it will become more clear as I go along. Thank you.
It's kind of tough. One path thinking and starts thinking in a multi-dimension, because we never really have been trained to do that. They've been training us in school to just think one-dimensionally, and that's it. And to get a handle on this public-private, how it works out, is a little tough to start out with. Your eyes hurt, but that's because you haven't used them. So just keep on practicing, and you'll get the hang of it. But
thanks.
It's really. What you were saying? Go ahead.
Okay. I just muted Stan out. Christian, let me find him again. Hold on. Where are you at, Stan? Here, hang on. Stan, did you have a follow-up on that?
Well, no, the system seems brilliant, but, the fact that, some of this stuff is hidden from us, the fact that our signature makes us grantor of a trust that we never even knew existed, it is. It's hard to think in these dimensions. So, I'm just trying to do that now. So I appreciate all these programs. They're great.
Well, that's what Gilbert Law is really exposing, the fact that it's really amazing that nobody needs to know or understand that a trust was being formed. And that's kind of hard to believe, but if you take the example, if I handed you my pen and said, I want my pen back, we've got all the elements and the method of formation right there, and that was a trust. If you didn't give me the pen back, I could take you into court and sue you under trust law and get my pen back. Because I was grantor beneficiary. I granted you the pen, and I wanted it back. That made me beneficiary. And I wanted that specific pen. That was my pen. So it was a special deposit to you. So you were the trustee. And if you didn't give it back to me, I sue you in court under breach of trust. So is there another question then?
No, I'm good for now. Thank you.
All right, Stan, just hit *1, Stan, that'll mute you out. And we've got, let's see, 301 area code. State your first name, where you calling from, please. 301 area code.
Yeah. You hear me?
Have?
Yes. Yeah. Andrew. This is Andrew in Maryland.
Hi, Andrew. Good to have you.
Yeah, how you doing there? Hey, I want to ask you a question here. If you have say that you have a lien, a perfected lien, or like a tort claim, could you take that and have like on a UCC1, and you have a trust. You put your trust down as the secured party, and in the debtor's name, you put your name like down as the debtor, and then take the lien and put that in the collateral box at the bottom, then have it registered. And after you have it registered, then you have it taken to a bank and open up yourself a bank account. And then when you open up yourself a bank account and they give you a checkbook, could you take that checkbook and everything and transfer it over on a UCC3, and record it and write checks off of it? Could you do it that way?
No. No, not one bit. It ain't going to work that way.
You couldn't do it that way?
You're like mixing apples and oranges, because what you're doing is you're taking a debtor-creditor methodology, and you're trying to get it to conform to a trust. And what you're not doing is you're not doing it as a trust. You're trying to claim that the lien, which is debtor-creditor, and you're trying to shove it into a trust.
Okay.
So you're combining the two. You need to treat the actual lien as trust res. Because anytime you use a UCC for debtor-creditor relationship, a secured party creditor, you're just back under public debt side system again, and you're right under the same system.
Okay.
You're not operating in trust.
Okay. How would you do that anyway on that?
The only thing I'm going to use the UCC for is to claim that I've got trust res property, and then I'm going to move it on a 3. Just for the creation of a record of the fact that I claimed it and I moved it. That's the only purpose I'm using a UCC3, not to establish a lien under debtor-creditor. Because as soon as I talk about lien under debtor-creditor again, it puts it right back under debtor-creditor.
Okay, I see, sir. All right, thanks a lot.
If you try to write checks off of that lien, that's not a special deposit. It has to be under special deposit, and that's the wrong place to put it anyway, in a regular bank there.
Okay. So, you have an idea how you do that? If you want to you probably could just write partials off of it then, right?
You have to do it all under trust. It's not under debtor-creditor. Partials on UCC there's nothing more than debtor-creditor again, which puts it back on the discretion of a discretionary trust, because we didn't pay the past war debt and we didn't pay our current debts. And then we never get into debts in the future.
Oh, okay.
You haven't claimed
all right, then.
the root. You haven't claimed the root.
Okay. There's one I was thinking, if you transfer, I thought you just like transferring stuff over, like that you could go ahead and do that.
You may get a amount of success with that, but I don't advise it.
Oh, okay. All right, then. Okay, thanks on that.
Thank you, Andrew.
Uh-huh.
Okay, we'll meet you back out, and feel free to do a follow-up if you need to. We've got, let's see here, we've got Ed outside of Washington, D.C., I guess in Maryland. Ed, you there? Welcome to the program.
Yeah, I'm right outside of Washington. I'm not in the heart of it, but I'm right outside.
Right outside the jugular vein of the beast. I'm opening your audio. Please speak up.
Okay. You got me now?
Yeah, you're getting better. Keep on talking. Speak up. Hit *6. Hit *6, or not star, just number 6 several times on your phone.
Okay.
Okay.
How are we doing now?
More. Hit it more. Number 6.
Nobody ever asked me to speak up. I don't have to. I'm pretty loud.
Well, you got a problem. Phone connection right now. Problem. Well, try hitting 6 about 5 times right now.
I tell you what I'll do. Let me pull the headset out. I'm on a headset. Let me just do that.
All right.
Okay. Is this better?
Absolutely. Thank you.
Okay. Sorry about that. I had no idea. I get that on occasion. I have a question. I came into the call late tonight. And again, forgive me if you have to be redundant. But if you're facing a divorce case, I'm trying to figure out, and I just started listening to Christian. You're trying to figure out what moving parts there are, things that are happening beneath the surface that you can't see. I have known that there are things going on where you're scratching your head and you can't figure it out. So, I've had this thrust upon me, and I'm looking for resolution and remedy, but I don't know what's going on, and I don't want to be, spending my effort trying to get remedy in the wrong direction. So, if there's any guidance on there, first I want to be, what is going on, and then how can I solve this issue without, getting the lawyers out of the picture.
Yeah. Well, you're in the same boat everybody else is, and it's no different from anybody else, really, except we need to see it for what it is, and what it is really a trust. So if we...
Okay, the lawsuit filed against me is a trust.
Yeah. There are trust upon trust, or, trust within trust. There are multiple trusts. And the purpose of all the trust is really to get you under debtor-creditor thinking so that they can come back and, actually get the access to the trust funds, which was, the SETI Key Trust. So that's what it's trying to connect into. But everything is a trust within a trust or subtrust, that's what we're looking at, is it being a trust. And every trust has the certain...
Right.
Same thing, same properties. It's got, the elements and some way of method of formation of the trust. And all we're going to do is reverse it, just like we did under the debtor-creditor, say, except for value, return for value, but I don't really like using that term anymore. But what we're going to do is, number one, we're going to express and prove the trust. And two, we're going to create the title and claim it, and move it and merge the titles. And then we're going to 3, collect on the disbursement, which is really the enforcement. So it's really like a 3-step process. Now that second step, I can effectuate that in 2 ways. I can either force the trustee to do his duty, which is to disperse the funds under equity, or I can merge the titles, and then he's without trust protection and he's personally liable, and he needs to disperse the funds. So either way, I don't care which way it is, you got them both ways. Which comes back to the step 3,
How do I know?
Like on a disbursement through a special.
Who is the trustee?
Well, here's where you only have 3 parties in the trust. So the grantor is the one who's signing the instrument, which is the offer that they gave you, was really a trust instrument. and they're looking for a signature or a grantor position on that. So whoever does the signing or whoever the ones that's sitting there holding the hot potato on that, that's the grantor. And then I would also probably want to be, in this case, since I was in court, want to be a beneficiary because the beneficiary gets the disbursement. So the trustee would be them.
Right. Well, obviously, you can tell by the nature of my question. I have to break it down to the least common denominator to put it all into workable mechanics, so I can get resolution.
Right. It really is simple.
Right now,
it's simple. Intent, purpose, parties, and specific res. There's only 4 elements of a trust. Well, intent and purpose, that's easy because that's by the grantor, so that knocks them out right away. So then parties, we just talked about parties. There's only 3 parties to the trust, and we practically named all 3 of those. So now it really boils down to specific trust res, which would be the case itself. I would claim the case itself as being specific trust res. So then all I need now is a method of formation of the trust, which is really, documenting the transfer of the trust res into the hands of the trustee. And really, he doesn't have to be holding the actual property as long as has been assigned, publicly assigned, that assignment, and he's been noticed, even though he hasn't even received actual trust property yet, he's still the trustee, and that's when the trust property was transferred. And as long as I can prove that with a record of what I've done, now I've proved the trust on my claim that there's a trust. So that puts me in a whole different realm now. That puts me under trust law.
Something happened to you. That puts you under, and then I lost you.
Yeah, that puts me in a different realm, puts me under trust law.
Okay. Once you put yourself under trust law by acknowledging, when you say expressing, is that, when you say that, use the term expressing the trust, what's another way to phrase that? What would be synonymous?
Well, it's actually a process. It's not something I can do and say, okay, I've just expressed the trust, but it all starts with the rule of signatures where I've signed the original documents, say, by grantor. And then I've got the elements necessary and the method of formation, the records to prove that.
Okay.
So actually,
not to monopolize. Yeah, go ahead.
It's like a process that I'm running a process, just like we did it on the administrative remedy process. We're doing a trust process of proving the trust, which is like a 1, 2, 3 step process.
Okay. Now, again, this all being somewhat Greek at this point. How do I do this so I don't walk into a mixed martial art fight as a white belt and get killed?
Yeah, that's what'll happen.
Where do I?
Your strength.
Yeah. So
practicing and studying the basics, like we've been studying out of Gilbert's law summaries on trust, and listen to the downloads from November and December and January, which consist mostly of the shows that I've given on Tuesday night and Wednesday night and Saturday night.
Right. Well, I guess in a practical sense, listening to those, how will I know? And when I've got the mechanics down and the knowledge base down, strong enough to know how and when to act.
That's easy. You can answer that question yourself by when you answer your questions yourself. In other words, when you don't have to ask me what's the verbiage for that or what's the understanding, now you can answer your own questions. Now you're ready.
Right. Yep. Well,
when you can see the first step to take, then that's when I would take the first step. And then when you can see the second step to take, that's when I would take the second step.
Right. Okay. Yeah. And again, I'm not approaching this as a silver bullet methodology, but I also know that there's something beneath the surface going on, and when I first started listening to your stuff, it opened my eyes immediately. I know, at least I would say I knew that I didn't know, but I knew there was something lurking beneath the surface causing more problems than I could identify.
Yeah, and it's disguised as a trust. debtor-creditor contracts, colorable contracts, wrapping and hiding a core, which is at the core was a trust. Everything's got to.
So a lawsuit is a
Yeah.
A lawsuit of any kind is a trust well, basically it's a trust disguised as a lawsuit.
Right.
Okay, I mean, is that accurate?
Yes, everything
Yes.
has to be a trust. There's no money. Can't complete debtor-creditor, can't complete a leasehold, can't complete anything without real money. So everything has been a fictitious lie. Doesn't exist. It's just an illusion that it's there.
Right. Alice in Wonderland.
Yeah.
Okay. Well, let me ask you this: if I need
speak up, you're so low. I don't know what happened, but you went way down again. Speak up.
Is that any better?
A little better. Thank you. Just breathe deep and get close.
Okay, I'm here again. If I need any individual consultation on this, how do you go about getting it?
Send me an email at christian@movingtitles.com.
Just Christian@movingtitles.com? Okay.
Yeah, right.
Will do. All right, good deal. I don't want to monopolize the call, so I'll just leave it at that, okay?
All right, thanks.
All right, thanks, guy. I appreciate it very much.
Yeah, if there's nobody else on there, call back, come on back in with another question.
Will do. All right.
Thank you, Ed.
All right.
Christian, I have a Skype question. And if anybody, again, you want to get our audio or our dictionary and the translations for the Peshitta Targum Restoration Project, go to our urgent tab. It tells you what to do there. We also have a rights document, the 12 articles on the natural right, what natural right was all about. Of course, we don't get natural right today. And our Skype-in name, if you want to ask a question or tag us to get a file transfer, we can immediately get you the dictionary. We can immediately get you all of that data if you want to make us a PayPal donation right now. We appreciate it. And our Skype-in name is Free America Radio. Free America Radio, one word, here in Kingsland, Georgia. Here's a question, Christian. I have a question for Christian. Where do you purchase the UCC with official comments that he spoke about with his course? I guess you spoke about with your course.
Okay, after I answer the question, can we go to a break then?
Absolutely.
Okay. The Uniform Commercial Code, the UCC, is published by, it's a Thomson West publication. Now, Thomson West puts out that book with the official text and comments. So the title is really Uniform Commercial Code, whatever edition is out there now, official text and comments, including Article 1 through Article 9, appendices and index. So check the site of Thomson West. You can get your UCC from there. So with that,
hey, Christian, take another question.
Yeah, let's go to some more questions in now.
Okay, and we got a Skype question. That's from Matt in England, but he's up after our other two parties that have been hanging in there. So let's go to Joe in Nevada. Joe, how you doing tonight? Welcome to the broadcast.
Hello. Can you hear me?
You're good.
Yes.
Yep.
Go ahead.
Yeah. How you doing, Desert? This is Joe McCool.
Joe, speak up. You're low. Hit six.
Okay. All right.
6 times on 6, 3 times.
Can you hear me now?
Yeah, that's better. Thank you.
Yeah, Christian. Could you explain the law of perpetuities?
It's out of Gilbert's Law, Get the book, it's in there. That's,
Yeah.
How you pertaining, how you using it? What's your particular usage of it?
To do with property tax? Property
tax. In what regards to discharging the property taxes, you mean?
Yes.
Well, again, really I'm going to treat all that as being a trust, because when you registered your property into the county, you didn't really know, but you were forming a trust. Because the previous seller was grantor on the warranty deed, and you're listed as the grantee, who is really the trustee.
So I'm listed as a trustee.
Yeah, you set up a successive trust, and you're the trustee on it, and you're the one liable for the payments of the taxes. Now, if you knew about trust, what you could do is you could terminate that trust.
Well, I tried to do a revocation of power of attorney and consent, and they wouldn't file it. They wouldn't recognize it.
Okay, how'd you try to put it in? Was it a revocation of power of attorney?
Power of attorney and consent to all the affidavits of that I have on file with their office that has to do with deeds and affidavit of gain and value.
Well, I would suggest go back to your county and ask them what are the requirements to doing filings, and you're probably going to find out that, by law, they must record affidavits and they must require notices. So, in my state at least, I'm going to comport my documents to an affidavit or to a notice, and they must record those. But I would go to my recorder and ask them, what's your criteria for recording?
Well, they said that I had to, since I was talking about a document, that I had to list the document number before they would record it. And I was referring to anything that they had on file with my signature.
Mm-hmm.
And they said that wasn't specific enough.
Okay, you might have to switch your documentation around and make it, to what they'll agree to file. And then my document title would be affidavit of something, or notice filing. If it says notice or affidavit, by law they got to record it.
Well, they told me to go to
you're revoking something on a trust. Do you really have the right to do that? Has there been a breach of the trust? And number one, go back even farther. Do I have the right to claim a trust? Have I proved that there was a trust? So if I haven't claimed a trust being first and then proved that there was a trust, then I've got no right to do anything at all. So first I got to claim a trust, prove a trust, and then go back and do something, say, in a breach of trust, and then be able to prove that there was a breach of trust. Then I would merge those titles and terminate that trust or get that trustee to perform. But then, you're the trustee on that, and that's what they're doing to you, trying to get you to perform.
Right. Well, the law on the title, on the property tax is if you decide to record it, then you're responsible for the tax. But there's no law that says that you have to record it. It just says if you choose to do so.
And you choose to do so because you did record it.
Well, they didn't. They had a good faith duty to tell me this, but they breached that.
Well, now you're under common law, which is really back in the republic, and that republic is held in trust and can't be seen in the public. So now you're commingling. So you are breaching the trust, and you don't even know it because you're commingling sides.
Great.
It really comes back down to you need a little more basic understanding of what's going on, how to apply it. And so once you can identify the elements of the trust, and then you can see it for what they are, then you can manipulate it into what you're trying to achieve. So it's like, stick with it. Get the Gilbert's Law Summaries book, and get the downloads, get up to speed to where we are. Start looking at it as a trust. See,
okay.
You're functioning in a statutory trust there in the county. Now, I want to recognize that statutory trust for what it is and what it's doing, and I'm the trustee on it because that's what you volunteered for. You actually signed the documentations and stuff that set you up as trustee, just like we did with the 1040 form. Declare ourselves to be trustee up there in that individual master file with the IRS. So that comports exactly with the county. because the county's got you as trustee also, and so does your IRS record have you trustee. So everything must come forth to the IRS record. That's the root right there, the IMF file. So once I see the elements and how it's operating, now really what I want to do is I want to maybe just treat that statutory trust a different way, terminate it, pay it, or I might want to come back in and just pull the whole root out, and that's going to be done by the Declaration of Independence, because that's the private side. That's where you're running it from anyway. You're running it all from the private side. All this public stuff is getting us into trouble. We just don't understand how this is going back and forth, and how they're tricking us to get our signatures on everything and setting up these trusts. And then since we didn't express a trust, then they're going to construe it. And they're going to construe it under debtor-creditor that we owed the debt, and here our special deposit would have been a payment, but no, it's under debtor-creditor now because we didn't express it, and now we owe on the debt. And we can go back once we understand it and know what's going on. We can go back and correct that. Does that bring any more clarity to it?
Well, it just means I have to do some more studying. Study your downloads and get caught up, like you said.
Right.
All right. Thank you.
Thank you, Joe.
All right, Joe.
Joe, hit *1. That'll meet you out, please.
All right.
And let's see, we've got Rhonda in the state of Missouri. Rhonda, how you doing tonight? Good to have you.
Good. How are you, Desert?
Doing fine. I have to hit *6 a few times, Rhonda. I guess everybody, as soon as you get on, hit *6 like 4 times, just out of, I don't know why everybody seems low, and there you go. Thank you, Rhonda.
How's that?
That's a little better. I'll work on it.
Okay.
Yeah, go ahead.
Hi, Rhonda.
Hi, Christian. How you doing?
Good. You?
Good. Fine. On the workshop, I noticed you was talking about successive workshops. How many workshops do you think it will take before we can start counting down 120 days?
Well,
and what do you hope? Go ahead.
That's really up to the person how quickly they're going to grasp it. That's going to, your own progress is determined by yourself, not by me.
Okay.
So have to take multiple workshops, to get up to speed, where maybe somebody learns quick and grasp it right off the bat.
Okay, so it's possible that one workshop could be enough for somebody to kind of really be able to
somebody like you might be able to get it right away because you're a diligent studier, I can tell.
Okay, well, I'm looking forward to it. Thank you for all your time.
Okay, appreciate it.
Here, Rhonda, hit *1, and that'll meet you out, please. Okay, we've got Matt, our Irishman in England, with his question. Going on from a question that Christian answered earlier, what is you had? Okay, that's good. That's English, huh? What is you had a perfect? What? Okay, it must be what if. What if you had a perfected lien that was 90 plus 1 days, and therefore an accounts receivable, and you took that lien and used your non-UCC UCC1 filing to assign that asset, accounts receivable lien, to a trustee and appointed yourself grantor and beneficiary of that trust, could you then instruct the trustee to use this asset to settle obligations that come your way?
Answer that in one word, yes. If I made a special deposit, treated it as a trust from the beginning, and I treated that lien as a trust res property. The answer is yes.
Okay. All right. Second question, follow-up. If there is a, excuse me, if there is time, okay, second question, if there's time. If you got an employee of, say, a bank to confirm in writing or email that they were the beneficiaries of an account that is in your legal fiction's name, would they now be obligated to prove that trust? And if so, how might you start that action?
So what I'm understanding is that he's saying that the bank is the beneficiary?
Yeah, he's implying this.
The bank would have to be one bringing the action.
They admit to it.
What?
Yeah. They admit to it. What he's saying is, if the bank, confirms in writing that they were beneficiaries of an account that was in your legal fiction's name.
Right. The only one who can make a claim on a trust is the beneficiary, unless the grantor has some kind of beneficial rights that he's maintaining for himself. So you could be a co-beneficiary as grantor on this, but if the bank is the sole beneficiary, they're the only ones who can make the claim. Now, do you think the bank is going to come at and make a claim? I don't think so. So you might have to switch that around and do something different with that one, because you want to make them say trustee, because you probably want to be beneficiary, so you could make the claim, or at least a co-beneficiary, because only the beneficiary can make a claim.
Okay, very good. Thank you for your questions, Matt, and say hello to the Queen for us. Okay, next question out there in Cyberland, across America, and we've got an infamous, notorious Dave in Florida.
Okay.
You better turn that computer speaker down, or whatever you got going in echo chamber there, Dave.
How about that?
Yeah, that's better.
Hit 6 a couple times. Boost your audio. 6 up.
Okay, let me take a hypothetical, just to make it clear for everybody. If I got an 89-year-old grandmother, she's got a house, she can't make the payments. She says, "Yeah, Sonny, you can be my trustee. Here's my power of attorney, do whatever you think's right." Now, she can go ahead and do her, I guess, her statutory side, answer the complaint with some kind of proof of claim, but then come in the back door, like you say, in Chambers and say, we can't really make the payments on this, and here's the reasons why. And my question is, how do you see that playing out if you know what you're talking about?
Okay, the older lady, she's what position is she again?
She owns the property. The mortgage is in her name, but she's 89 years old. She's just doesn't really comprehend everything. But she says, I'm going to lose the house anyway because the payments are so high and my income's so low. So I'll tell you what, if you got a way to figure this out, and all you need to do is be the trustee, have at it.
Okay, so she'd be the grantor.
Exactly.
And then you come in and say you want to do it for her, but you're going to come in as trustee? Is that what you said?
Well, I'm a trustee at that point, but like you say, when you go to the court, in the chamber, you want to...
At that point, I think you've got power of attorney as grantor for her, because she's grantor.
Okay, then I can assign as grantor by power of attorney the judge to be the trustee.
Yeah. Right.
And if they balk at that, I'll say, well, look, it's an qualified power of attorney.
True. As long as you got power of attorney and she's grantor, then you'd probably have to prove that, she was the grantor on there, so that she had
Yeah,
the ability to do the appointment of trustee.
that would be basically going back to your SS5 and showing that in the public record that it exists.
Well, if it's a foreclosure case, then actually it's the case itself was what I would treat as trust, as a trust. So she's the one. She's the one that's holding the case.
You're going to prove
under the UCC 3-105. It's really whoever signed the instrument. So what was the original note? She signed the original note, and whoever the original note, that's grantor. I keep coming back to that out of Nevada, that bankruptcy case where the judge said that the signer of the note was the trustor. The trustor is the grantor. And the payee on the note is the beneficiary, and the payee is probably the bank. So the bank is the beneficiary. So now you got a problem because the note is made out by the grantor that way, and it's probably going to have to be that way. The trustee was actually the title company per power of attorney of her.
right, but she can revoke that at any time.
Yeah, if I had I would like to see that I would have a legal reason to do that, and that's where I do like a debt validation request, and when they fall down on that, I would certify that by a notary, which would give me a dishonor against them, and that dishonor then I could use for a revocation of the signatures then. So that would give me the legal standing to do that, and I would do this all under trust then. Then I would treat the note as the special deposit, and start creating the evidence that I made a special deposit back when the note was closed at escrow closing. Then
now, how do you verbalize this is a special deposit? And you're going to explain that to somebody who doesn't know what you're talking about. Can you elaborate on that a little bit?
Yeah, that's where you have to get the banker's handbook, bank officer's handbook of commercial banking. That in there explains special deposit. And we've gone over that.
Okay, so
shows.
Yeah, you're right. You did say, well, pursuant to the banker's handbook, special deposit is XYZ.
Mm-hmm. In fact, even special deposit has gone over a little bit in Gilbert's law summaries.
Now, is that all there is to it, basically, for a mortgage?
Well, then I'm going to change those positions on there for reappointing the bank to be also trustee, because now they're beneficiary. When I make both entities or both titles then in one entity, merge them in one entity, the trust terminates. And I would probably give a conversion order for them to convert the special deposit and to ledger the account to zero, because that's the definition. Definition in black.
You're giving that order to
was trust deposit, which is simultaneous, same thing as a special deposit, where it said that the deposit by the depositor was for his purpose for paying any debts or obligations.
But you're giving this order to the new trustee?
Yeah. Well, as soon as I merge the title into the bank, because the bank is the beneficiary, and if I give them the other title as trustee, then they've got both sides of the title. Trust terminated. Now they got no protection.
So okay, but if you're giving an order and there's no trust in existence now, who are you giving the order to?
Well, before I moved the titles, I would ask for the, I'd make sure that I gave it to them as special deposit. So this is going to, like everything's going to happen just more or less simultaneously. Merging the title, full deposit, and asking them for the trust property back and the conversion, like all in one.
Right, and because they fail to return the trust property, then you do one of the other actions.
Yeah, now we got conversion, and with the other causes of action, unclean hands, we got unjust enrichment, we got unfair dealings, and then the big one we come in with antitrust, because they got a monopoly. They're not dealing fairly. Special deposit in Gilbert
Hey,
is on page 30 under section 111.
Section 111 and what?
Gilbert's.
Oh, okay. Now, if you're through explaining that, I wanted to just shift it over to another similar issue, only it's a credit card, where you've asked them for the trust property back, but their response is, well, we did this over the phone. We don't have a written agreement.
Well, that's true. You don't have a written agreement. But a trust can be formed orally. And you guys didn't even know or understand a trust was being formed. Oh, but by the way, here's my confirmation of trust res property and my proving of the elements, and now we have a trust that the law will recognize. And I'll see you in court. I'm suing you for breach of trust.
Well, I guess we'll learn a little bit more about that in the workshop.
Yeah.
I'm so glad you're having that. Did you have a starting date set up yet?
Well, I'd like to get it, do a little promotion first, fill up the class, and then probably start it at the end of the month, or maybe it's around 1st of February, something like that.
Okay, great. Well, thank you for answering my question, and I'll let her go.
Yeah, go. Did you get the website, movingtitles.com?
I did. I already asked you for the registration form.
Okay, all right, great.
Check next day email. Thank you.
Hey, Christian, you ready for another question?
Yeah, go ahead. Give me another one, yeah.
All right. We got Mike Malone with an E on it, so I think it's Malone, silent E, not Maloney, from England, Liverpool, and a personal friend of Peter Cooney, whom Christian knows. And we're getting some feedback there. It's probably you, Dave. I want to mute you out. Hit star 1, everybody. When you get done with your calls, hit star 1. That mutes you out. Thank you. According to the great Canadian Vic Beck, under a monarchy, Her Majesty's promise to pay, quote unquote, means that the public is the beneficiary and man is solely grantor. Because Her Majesty, a legal fiction, holds title to all legal names in the UK, Her Majesty is holding our sovereign lands in trust as we do all the work and provide the services, and she pays for all of the contracts through the names that she holds title to. Have you heard of this, Christian? Thank you.
It's the same thing here as it is there. Yeah, but you're claiming trust now. Now prove trust. And then do the enforcement. Either merge the titles or force compel the duty of the trustee. And then collect on the disbursement.
Our Canadian program, just prior to this, with Doug Shapiro. Doug is a really sharp guy, and he's doing a great job. And he, the Inside View from Canada, 5:30 every day before Money, Banking, and Trust, and he was talking about the term notwithstanding, and indicating it's got a legal meaning that it's on we're on the water. The reason we can't stand is because we're on the water in their legal fiction. On the Admiralty high seas, and
yeah, but it's not.
Those are my words.
It's really Admiralty's on a
right. Well, trust. Right. Okay, debtor creditor. Okay, there you go. But he was saying what it meant was
like Admiralty, but trust.
Right. What he was implying is that that anybody they wanted to throw 10 men off the ship, they could do that, notwithstanding. The implication being it's in the best interest of the Queen. And so basically, notwithstanding means you don't have any standing.
Never proved trust. Never expressed the trust. Never claimed trust. Never proved trust. So now they're going to construe it under Admiralty.
Right. Mm-hmm. Okay. Anyway, just found that an interesting expose on the term notwithstanding.
Well, let's say that on that ship, that all the people on the ship, they were all beneficiaries. How are you going to throw the beneficiaries off the ship? Really, it's the captain's the trustee.
Yeah.
They got it backwards, see? They're construing it backwards so they can throw you off the ship. But all you had to do is raise your voice and express a trust and be able to prove the trust. And now you beneficiaries, you're the ones that were really the grantors and beneficiaries of the whole thing. Now the captain's got to listen to you. It's the reverse because you never expressed it and never claimed it, never proved it. It allowed it wide open to be construed under admiralty or debtor-creditor, contracts, colorable contracts, leaseholds, all this stuff that involves commerce being fiction money that doesn't exist, but really it's a trust. I mean, it really is a mind-warping concept once you get your mind around it. Because we've been so trained to be thinking in a box with our debtor-creditor relationships. From the moment we were born and sent to school, you were taught to write your name in big letters, in capital letters. To ingrain it into your mind, to burn it into your mind that you are the straw man. You know, but it's all trust. It's a trust. That cap name is a trust. I need to look at it as a trust, and that's my puppet, and I'm manipulating him. Learn how to pull the strings on the trust. Learn how to administer the trust. Learn how to express the trust, claim the trust. Learn how to move the titles around. Because we're really moving titles and trusts functioning as commerce. That's the whole thing. You have to bond the case, and it's bonded with the trust. A bond is the trust in a trust relationship. In a trust, you are the lender of the asset held in special deposit. Don't express the trust, and you're the debtor under UCC, debtor-creditor relationship. The remedy is not in debtor-creditor relationship as secured party creditor. Remedy's in trust. It's commerce through trust and equity. Trust, moving titles and trust, functioning as commerce. Like I've got a different view of everything because everybody's still stuck in a debtor-creditor box. And they have to come over to the other side and start seeing it from this side. And there are people who are starting to think about it, and they're coming over. Because this makes better sense. More better sense. So that's real grammar. This makes it makes better sense.
Okay, settle down, Christian. We got Matt with a follow-up in England again. Third question. If there is time, we've got time, Matt. It is my understanding that we are the beneficiaries of the Social Security, National Insurance here in the UK, and as the beneficiaries are, and as the beneficiaries are entitled to know the trustee's name and address, who might we contact to enforce those details, and what might we do if they don't provide those details? Thanks.
Well, I've been thinking more along the line of who is the grantor, because the grantor's intent and purpose, he should know who the parties are. So that's the starting point. Who's the grantor of all this? Once you discover who that is, then you better ask him who the parties are. Because it's the intent and purpose of the grantor that he sets up the parties, grantor, trustee, and beneficiary. He knows what the trust res property is. So if you want to be the one controlling the whole situation, you better find out who the grantor is first. And knowing who you are is not knowing that you're secured party creditor, but knowing who you are is knowing that you're grantor. So connect the dots.
520-520 area code. State your first name. Where are you calling from?
Hi, this is Tim in Tucson. Christian, I was just on your site.
Wait a minute. You're real low. Who is this? And hit 6 about 6 times.
This is Tim.
And who do we have?
Tim, Tucson.
Tim in Tucson. Speak up, Tim. Go ahead.
Sure. Christian, I was just on your site. Brand new, obviously. I'm sure I'll find out from the email that I've sent, but I'm curious, are you like most in that you're requiring payment via money order? Or are you accepting cards? What fashion?
Probably both.
Okay.
Either or, one or the other.
That's what we're doing. Yeah. All right. Well, that's wonderful to hear. It'll make it a little easier and such. And I believe I heard you say it looks like a couple of weeks yet before it starts. Will you have one that will begin right after the 5-week session?
Yeah, probably.
You offer,
and then start another one. Yeah, right after that. The workshops will probably be an ongoing thing.
All right. So if one wasn't comfortable in jumping in now, 5-6 weeks down the road, there'd be another one opening up.
Right. What I plan to do is continually doing workshops all through the year. Then I'm going to do 4 live seminars at different locations in around the United States and the world. So before those, and we'll go from there. So
let me tell folks that I was fairly impressed that you got back with me. I fired off a question about a particular doc someone wanted my help with, and I included you to that request list, and you got back at me pretty quick, and I was grateful for that. A little bit of information in there as well. Understood where you were coming from. Not a doc we want to use, but there's so much to be learned here. The application of this information seems to me one should not apply it until they've come to understand it well and feel comfortable in using it. As you've said, when you're ready for step 1, you'll know it too ad infinitum. Certainly this can't be used with creditor-debtor technology. One has to be ready to make the shift. And I presume you would agree that you don't make that shift until you've been through the whole course and understand what the heck's up, correct?
Right. I wouldn't suggest it until you got the basics down, and a good place to start is that Gilbert's Law Summary for less than $30.
Right. Okay.
And we've been using that, and there's quite a few audio tapes available since November, that can be downloaded, so to study along with the Gilberts.
I see, and that makes good sense. So that would be a beginning if one wasn't quite ready to jump into the program. I don't feel quite prepped enough to jump in, understanding what this is all about, having only listened to, say, 3, maybe this is my 4th time or something.
Right. There's quite a bit to get down under your belt yet. Did you get the download link page with all the links on it?
No, I'll have to send you an email. I thought I had. Maybe I hadn't.
Yes,
I'll be sure to do that.
It's about 3 pages long, and if you click on the links, it takes you to the site where you can download the audio, MP3 audios. So if you send me a request at christian@movingtitles.com, then I'll send you the link page for the audios.
Okay, so again, you would suggest somebody who's fairly new to what you've got here might be better, rather than diving into the workshops now, get a little under their belt first, a little understanding?
Yeah, you could maybe use one workshop to get you up to speed, while you're studying some other stuff without attending, and then join in on the second one.
I see. So you feel like it might be a couple of workshops necessary to really get a full grasp, a working grasp of this, huh?
I don't know. It depends on how much time you have to devote to, reading and studying. Some people are like a sponge and they're really quick to understand, and some people it takes a little longer. I can't answer that for you.
Understood. Yeah, as you said, depends on how quick a study one is, how much effort they put into it. Let's go to, for a moment, if we can, the successes. clearly this sounds quite valid, like it indeed does work. Have you had stories coming in of folks who have taken the judge back for an in-camera hearing and
we're brand new at this. We're riding a wave, and we're putting paperwork together that doesn't exist yet. So we haven't quite gotten that far to where we're progressing solely on trust. So it's this is really a ground. You're getting on the ground level here.
Okay, so I don't know that I had that understanding, but I have that now. So this is new trust technology, and
on how we're using it, because trusts are really not new, because there's been trust out there for hundreds of years, but in fact, even today, people are using trust, but they're using trust as a defense mechanism. They're using it as an asset protection under debtor-creditor, so that the creditors can't take the debtor's assets. So they're using it as asset protection. And we're not using trust as asset protection. We're using trust as offense.
Right. You have an inordinate knowledge. Someone pointed that out to me, that you seem to know this particular book inside out, backwards, forwards, upside down, that sort of thing. Would you explain where that knowledge comes from?
I came from debtor-creditor, for one thing. So I've studied trusts because that's the title of the show, Money, Banking, and Trust by Moving Titles and Commerce. And we've been doing the show almost 2 years now. So to come up with materials that's new for the shows, I've been continuously studying and increasing my knowledge. And the more that I study trust, I see a totally different realm that I saw before under debtor-creditor. And it has really hit me that trusts are running the whole thing. But yet, you get some of the wigs out there that are saying the same thing, but nobody is really going down the trust rabbit hole. We are. Nobody is. Other than
I just want to add, for the guy's question, Christian, knowing you, and Christian studies, like about 8-10 hours a day, if not 12 or more. So he pays his dues.
Well, clearly, as someone pointed out, he knows that book so well. And then I had listened to the seminar a few days ago, and I thought, by golly, my friend is really right. You had spoke of a particular section is referenced in this, that, and the other section. And so clearly you have a thorough grasp of this tome that you're working with here. And I see there are also a couple others you suggest we utilize, the blacks and such. And so let me just toss out the Wuffet work. It seems to me that it coincides with this in that it is focused on prosecution. If someone doesn't give you your remedy, i.e. that judge, shakes his fist at you and has a bailiff try to cart you away or something, I don't know, whatever could come, and this should not work out. I recognize that you see this as what's supposed to be, and if they don't, now we're going to have to go after them to get our remedy.
True.
And that would be, say a court. If a court's not allowing you to pay in this set-off fashion, you take them back for an in-camera hearing saying, I can't pay, but I have this set-off and a piece of that. Take a hike, son. You could say, Judge, are you sure? You're in violation under color of law of a couple of Title 18 and Title 42 challenges there. So, again, if this doesn't work, you're going to have to go after them with some sort of remedy. Prosecution to get your remedy, it seems to me. Does that fit with your thoughts?
Yeah, but I would come in with trust right off the bat, not under debtor-creditor, right? I wouldn't be mixing the apples and oranges. I'm going to come in pure trust. I'm going to come solely from a trust basis.
Right, but this is, as you've said, agreed, fairly untried. No real successes to speak of yet, so if it's not working, essentially you're going to attempt to make it work by, bringing suit against the judge under Title 18 or something for not allowing you your remedy in commerce.
Yeah, if I had a statutory trust, I would use statutory means to prove that he broke statutory trust laws, yes.
I see. Okay.
Or I come in with the big hammer, the private side trust, Declaration of Independence.
Right. Okay, a lot of questions there, some pretty good answers. Let me slip away. Thank you much.
Hey, thank you. And that's Tim in Tucson. Star 1, Tim mutes you out. And let's see, we've got follow-up from Ed outside of D.C. Ed, go ahead.
Okay, yeah. You can hear me all right again?
Yes. Mm-hmm.
Star 6 it, please.
Let me star 6 it again. There's 6 times.
Thank you.
We good?
Yes.
Yeah, you're better. Go ahead.
Yeah, it's interesting to asking the question. Christian, how long did you study or apply the debtor-creditor mentality? I have 2 questions, a 2-part question, before you had your, for lack of a better word, your road to Damascus experience here.
Yeah, well, I have about...
Is that a fair question?
Yeah, I have about 15,000 hours involved in study here on debtor-creditor, from everything under common law to litigation in court to the whole gamut. And I probably got about 3,000 hours just in litigation method alone. And, now we're starting down the trust. I probably couldn't see it the way that I see it unless I had all that. But, I've been sifting through a lot of materials, and I can give you, I've already separated the wheat from the chaff, and I can give you the wheat, and you don't have to go through the chaff.
Well, that's great.
How far back did you start? How many years you've been studying?
It's not the amount of years I've been in it, it's the amount of hours I've got in it.
Oh, I understand. Yeah, but I was just curious when you got into the arena.
Most people, only study like maybe 5 hours of the week at the most. Well, say there's 52 weeks. Let's round it out. Say there's 50 weeks in a year. They only get 250 hours a year study. But if you study 10 times more, you get 2,500 hours. But even at 2,500 hours, I found the break-even point in debtor-creditor was you got to have about 2,500 hours in this before this stuff really starts making sense, under debtor-creditor. And then the rest of it was just studying all different other methodologies from A to Z to figure out where their basis is coming from so I could put all this together and see which one makes a better sense. And you know what I came across? That none of them make any sense, because none of them have any tried and true method of success, only about 10%, less than 10%. I don't care what methodology you use. Now that started to make me wonder, what's going on here? How come some guy that's had a success out here can't tell this other guy how to do it, and he duplicates it, and how come he doesn't get success? Well, there's something wrong. And when I hit this spendthrift trust thing in here, along with the discretionary protective trust and the discretionary trust said that it's per the discretion of the trustee that he gets to withhold or whether or not you get success in your remedy. And I thought, bingo. Man, that's the big one. They're making you go down the debtor-creditor rabbit hole, feeding you a little bit of success, which is really enough for them because that is creating the money and the bonds in the background that they're using as debt in their fiat currency debt system that they're using for money. So that satisfies their needs. That 10% of the people who are falling down into the trap and getting caught up into the system are actually funding the whole thing. And they don't really care whether or not you have success or not because they got their money either way. So if you're a defendant that lost, you're still funding. If you're a defendant that won, you're still funding the same thing. And it doesn't make any difference to them which way it is because they win-win. They're in a win-win situation under debtor-creditor, except they don't want you to know that it's trust. Per the discretion of the trustee on the trust. And when you get that concept down, now it's the curtain's been revealed and Toto pulled it back, and now it's the little guy out in the hallway there behind the curtain that's running the whole thing. And it was all an illusion. Welcome to Oz. And the truth was that you had the power all along, the slippers you were wearing all along to get back home. All you had to do was click your heels together 3 times and write title and interest, 3 clicks. Right title and interest is trust, and you'd be back home in Kansas. So that's my take on it.
What happened? Okay, well, I guess, from a personal note, what was it that woke you up again? As you're going down the...
The whole thing?
Yeah.
Well, what got me into this to start out with was... when I realized that there was no money, because I always thought that you went to a bank and got a loan, and they went in the vault and loaned it to you, and they gave it to the person that I was buying the house from. And when I learned there was no money and how things were functioning, that just got me angry, and I started studying it. And the more I studied, the angrier I got, and it just led into a snowball. And I just had to have, my mind is like a parched, dry land searching for truth, like rain, looking for the desert, looking for rain. I have a hunger for the truth.
Well, I'm with you there. And first of all, that's it, and then you got to know where to find it.
Yeah, well, that's what prompted me to start studying everything under the sun, because I have read everything out there. I've read it. You people send me stuff, you think it's new. I've already read it. I don't even go through it. I just trash it. I've read just about everything there is. There's not much new that isn't. And when I read something, I can tell pretty quick where their epistemology is based, where they're coming from.
Right. Well, I hear you. I appreciate it, just to know, because it's interesting to know what the catalyst was that moved a person from one paradigm to another. Okay,
when I shifted from debtor-creditor trust, it was really after I kept on studying more when I had the show, when I started the show, and it became clearer and clearer that trust is running the whole thing. The more I studied trust, it was revealed that to me.
Okay.
And I'm sure that if you keep on studying trust, you will see the same thing. I was
good. I mean, I'm
the show. I had to come up with new material all the time.
Well, I'm hoping what you've done saves me a heck of a lot of time, not going down the wrong rabbit hole.
Yeah, all the time we've been going down the wrong rabbit hole. Yeah. But they're leading us like a nose ring and a bull down the path they want us to, because. Or like a hound dog on a scent trail, the little scraps is keeping you on their track where they want you to go, because they don't want you to know you need to be going the opposite direction, and the opposite direction is trust.
Right. So it's what we did in war. It's subversion.
Yes. Disinformation. Yes.
Right. You start a little brush fire over here. Create a ruckus, give people the appearance of some successes, let a few of these mortgages go because they know they'll get the rest of them.
Mm-hmm.
By keeping the a few dissidents quiet.
Correct. Yeah.
Okay.
Section 490 in Gilbert's book on page 138 is talking about discretionary trust, and it says a discretionary trust is one in which the trustee, that'd be the U.S. bankruptcy trustee, say, the trustee is given discretion to make or apply or withhold distribution of income or principal, or both, to or for one or more beneficiaries, whether or not the instrument provides standards for the trustee's guidance. Oh, man, if you tear that apart, put it back together, it really makes sense. So here we got this discretionary trust because the creditors are trying to get at the beneficiary's asset, and here the trustee will not release the funds to the beneficiary as payment. So he withholds, because as soon as he does, the creditors are going to jump on the beneficiaries. So to not defeat the purpose of the trust, why the trust was created, and the trust was created for a protectionary trust under 498, to protect the assets from the creditors getting. So it makes perfect sense. So here's this trustee withholding, per his discretion, the disbursements of the income to one or more of the beneficiaries, we the people, either one of the we the people or all the we the people. Because basically we didn't pay the previous war debt, 1776, and we aren't paying our current debts because we're in a debtor-creditor system, a fiat system, which keeps us perpetually in debt. So if we stop doing the debt system, then we won't incur any more future debt. So if we pay the present debts and we go back and pay our past debts, now we don't have any debts. Now we're solvent again. There's no reason for the creditors to seize any assets because you paid them. Now there's no reason for the trustee not to allow the disbursement of the trust. So I hope...
Okay, Christian, we have...
I hope you see that.
All right, good enough. Thank you.
Ed? All right, Ed, thank you. We've got some more questions we got to get through here. And star 1 will mute you back out, Ed, thank you. And we've got, let's see, we've got Imagine, wherever Imagine is out there in cyberspace. Desert, please ask Christian something for me. This is Eric from Florida. Okay, that was Ed in Washington. Ed, you just did something. Okay, this is Eric in Florida. All the trust that we are expressing on the private side are... let me try this again. This is Eric from Florida. All the trust that we're expressing on the private side, he's not asking the question right. Are all the trust that we are expressing on the private side constructive trust? Christian?
What they're doing is they're getting you on the public side. They're getting you under the statutes and code construment of the public side trust, the statute and code trust on the public side, not the private side.
Okay.
They can't see the private.
Okay.
It's the statutory on the public side they're getting you.
Okay. As Christian so efficiently ties the Wizard of Oz to all this, is there a specific relation or reference that Kansas from the movie has to this new technology?
Yeah, it depends how you look at the movie, because as soon as Dorothy came into Oz, the house fell on the witch. The good witch appeared and granted her the slippers. There was a trust. And they all had to go to, do through all this stuff until finally at the end of the movie you found out that she had the ability to get home at any time she wanted, except she just didn't know. And then through the studies I did under Black's Law 8th edition, you can look up under trust. It says in there that your right, title, and interest, there's your 3 clicks. It defines that under that trust definition. Interest is the right that, a certain kind of right, it says, that the beneficiary has against the trustee. And it says it's a certain kind of interest that the beneficiary has against the trustee. And then it talks about property. Property is represented by title. So there's your right, title, and interest. So right, title, and interest, anytime somebody talks about that under debtor-creditor, is one of those portal terms, can be interpreted to be under trust, if that's what you're familiar with, or you can be duped in under debtor-creditor with the same wording. It can be played on either side. Just depends on what you understand and what you know.
Okay, we have a follow-up from Mike Malone in Liverpool. Here he goes. And I was officially told over my phone regarding my electricity bill after I expressed the trust with the 3 parties and my intent, etc., excuse me, that my oral conduct was enough as stated in Black's Law. Then, and after much convincing, they agreed to accept the bill for value and gave me the address to send it to. No letters necessary.
Okay, it sounds like debtor-creditor again, really, though. Did you make a special deposit under a trust deposit, under a trust?
What he's saying is, as a footnote, is my tongue opened the trust.
Okay, but where's the record, which is the manifestation of your intent and purpose? They have to see a record, or else you haven't proved the trust. You have to understand how the public side operates. They have to see a record, a piece of evidence, a material fact piece of evidence that supports your claim. If I gave an oral declaration, what is the proof that I gave an oral declaration? Where's my proof? Do I have a couple affidavits, sworn affidavits, and have them recorded in the county and pulled out certified because now it goes outside the hearsay rule because it went through a public record under rules of evidence? It's outside the hearsay rule? Because an affidavit, even in court, their public court, is the lowest form of evidence. It only points to that there's a competent fact witness that can be put on the stand and cross-examined. And that's what has to be done to prove an affidavit. There has to be a real party put on the stand, sworn in under oath, and they have to be able to cross-examine them. And that's where the truth is going to come through, which is opposite under commercial and the private. So it's not knowing how they're operating for one thing, but where is your record? They have to see records, two witnesses.
Yeah. What he's saying is, they just agreed. He's following up here on Skype. Well, they just agreed the correspondence center will deal with it.
Yeah, did they agree that there was a trust, or did they agree to do a set-off under debtor-creditor?
Did they? Yeah, it takes about 10, 20 seconds to go to England. So just we'll see if we got an answer there.
Yeah, if they did an acceptance on what you think you were asking for, and they came back and hit you with another offer, and then you ended up accepting their debtor-creditor offer, and then they put you back under, a set-off, but you were still under debtor-creditor. You didn't. It doesn't sound like you came at them under trust.
Here's the reply is coming right now. Make it quick, Mike. And by the way, I want to remind everybody that the Forbidden History series is coming up next, the Starfire Chronicles, and the occult nature of our world, symbolism, the words, the etymology of words, all coming up next, right after Money, Banking, and Trust. Christian is here every Saturday at 7 p.m. Eastern Time on the realpublicradio.net. And please tell your friends about the broadcast. You wanted to know, didn't you? Of course you did. Mike, you're going to have to make it quicker. Come on, get that pen. Drop that pen, and there it is. Okay, I exclaimed that I was grantor.
Well, that's
his exclamation point.
That's an NOI. That's a claim, an NOI claim. But where is the proof? Where's the SOI in support of the NOI? If there's no SOI in support of the NOI, then you've got no claim. They put you back under debtor-creditor again, construing it back under that.
Okay, very good. And we're going to go to
do basic government with
in Florida.
We don't know how to take and prove it. We don't know how they're operating in court with the NOI and the SOIs.
Right. Welcome to the call, Charlie. How's it going out there in Florida?
Hey, Desert, how are you?
We're doing okay. We're back up on the air.
Yeah, good. I'm glad to hear that you got settled in there. That's real good to know. And Christian, are you there?
Hi, Charlie. How you doing?
Charlie?
Yeah, hey, okay,
yeah.
Okay, good to
Charlie,
hear you.
Hold on.
Yeah.
Hold on. Hit about six times real quick.
Okay. Is that better?
Yeah, that helped. Thank you.
Okay, good. Yeah, Christian, hey, it's good to talk to you again. And I guess there's a couple things I wanted to ask you. And also, someone obviously listening in here, there were some other people that came on that some of the things that may help with them would be to let them know you're familiar with some of the things that are going on. Because some people seem to be leaning towards, well, what has happened in situations, or has there been proven situations that they can see successes by? Just real briefly for the people who wouldn't know me, I'm involved in a case right now, and without getting into a lot of lengthy explanations about it, I've come up to the point in talking with Christian to get to the place where there was an objection to a sale that was made on the courthouse steps of a piece of property, and I made an objection to the sale. And my objection to the sale was expressing the trust in the form of, well, it came as a what was it, Christian? A restraining, not a restraining order, but what did we put in? Something. What was it?
Throw, you mean?
Yeah, that's right. Temporary restraining order, and then a notice of interest at the sale that anybody bidding on this, that there is an objection to the sale based on the expressing the trust. And then I put that in, and I'm coming up on a hearing on the on what that is, I guess, or what, where I'm going to have to go in and explain that. So that brings me to some of my questions. And first of all, the idea of the grantor,
and Charlie, hold on, before the idea of the grantor, hold that thought. It's 6 again. One more round, okay? Because we got you, but we still need a little more. Please.
Okay. Is that any better?
Well, not really. Just breathe deep and go for it. You're still
okay.
Where you can hear.
All right, I'll try to.
Hey, that's better. That's better. Thank you. You got it.
Okay, good.
Yeah.
Good. Okay. Generally, I guess, and I'm trying to catch up on the audios and the reading in Gilbert's. Okay, so I'm doing my homework, but it's just I'm a little bit behind the curve yet. But as far as the grantor, without let's just say the SSN application process, where we were able to use some kind of evidence based on that. In my case, I wouldn't be able to do that before the hearing and have enough time to bring that in.
Right.
So I guess as far as expressing the fact that I am the grantor, help me in my thinking here. If, for the sake of understanding this, not going into another technology, but for the sake of understanding, if I understood 1099 OID and 1099A technology, is that where I'm coming from in saying that, hey, who was the original issuer anyway, or where did this come from? Is that the concept that I'm trying to bring about as the grantor?
Well, the offer that they send to you for the case, that would be the offer to turn it into a trust or a debtor-creditor, depending on what your knowledge was, depending how you accepted it. So if I knew that I could turn it into a trust, I'm going to treat that as a trust right then, and that's the starting point. So whoever signed that indictment or instruments there, like if I gave them a payment on a money order or something, the signer is the starting point. Wherever the signer starts, that's the signature. That's the starting point of the grantor.
Okay, so let's just use the case number for example, and wherever that started with the clerk or something or whoever, as that came about, when that number was created, it was created as an offer. And if I was to come back and say, well, that number was generated by my acceptance as the grantor.
Right.
Okay, so that's what I'm doing there. Okay, I got that. All right. So then the SOI. Okay, so I've done the NOI. Might be that I'd say, okay, I have other res property. For instance, the very property that was in question that was sold on the courthouse steps, that property can now be res property in the trust if I was to do like a UCC1 and then take the UCC1 that I got back and then recorded that, took a certified copy of that, put that in to the in-camera hearing in the res property of the trust. Does that make sense?
Yeah, that would create one witness, and I would be creating another one in the county, a notice in the county.
Okay, and I didn't lose anything. I didn't waive anything by taking the UCC1 and recording it in the county recorder's office?
Well, I wouldn't record the UCC1. I would record a notice to the county. Because that's
so
what a UCC one is, just a notice anyway.
Okay, right.
So one on a UCC and then into the county, the second notice. So there's my two records, my two witnesses. So now I got two witnesses, two records to establish the fact that, I'm grantor, say, that was trust res property.
Okay. So that is just something of a notice that I create. It's not any particular type of protocol that they're going to recognize. It's just going to be, I'm giving you notice that there is a UCC1 filing on this, and I'm going to file that. Is that, or I'm going to record that?
Yeah, that's all it is. They just have to give them notice.
Okay. So the notice, as long as it says notice, like an affidavit, then that's going to create the requirement for them to record it.
As long as I make up, public record of a notice without the detail.
Right. Okay. All right. Now, in addition to that, let's say I have a affidavit of obligation commercial lien that has been perfected through the notarial process, through defaults, through notaries, the whole works. I mean, for a better way of explaining it, I think I talked to you about it before. It's like Winston Trout's affidavit of obligation on steroids. It's like that, comes to $13 million or something like that.
Right. But it's that into trust res property also.
Excuse me?
I would turn that into trust res property also.
Exactly, and the same way I would do that is by the UCC1 filing on that, and the same process that I did with the other one, right?
Right.
Okay. Which, by the way, and I won't get into it now, but that's one of the other things I wanted to talk with you about is the UCC1, how it actually is filed, because now after reading Gilbert's Bailey and Baylor, they take on different meanings, and it's not clear how I would actually fill that out, but maybe that's for another time, But then there is a third res property that could actually go in there, which is the taking back of the property itself from the county through the I guess the recorded document.
If it involves the county, it might be that might be a separate trust.
Okay, all right. So that's something other than all right.
Yeah.
Okay, all right, and then I have down here some notes. One of them is, and again, going back to the actual hearing, okay, the case, and this is where some of the people who had called and asked questions, it may answer their problem. One brother who was on there, I understood his position. It was almost like what he was asking is, the only way you're going to be able to really know what to do is to have a mock court. And believe me, that's probably the most valuable thing I think that we could ever have, but it's very rare that people do that. But anyway, in a mock court situation, when I go in there, and it's already happened, the attorney for the county has already made statements like in the objection to the sale, he said he objected to the objection by saying that objection is not a valid claim. So if that was to come up with you, how would you come back and say, what do you mean it's not a valid, or what would you say to him?
That's his objection, but where is his material fact to support his objection?
Okay, so it would be a matter of
have a reason.
What material?
Have a reason behind his objection.
Okay, and if I that leads me to another question. If I based any of my
let me go back. That reflects things that are not entered into evidence, and that's based on conclusions in law. That doesn't represent any facts entered into evidence. There's no fact evidence to substantiate his objection.
Okay, all right, got it. Yeah, okay. So he comes, or part of my stating or part of my evidence is based on something that was in Gilbert's, and if he's slick enough, could he not come back and say, well, why are we accepting that as authority? What's Gilbert got to do with this? Why are you saying?
Gilbert's is really based on the restatements of the Law and Trust, the second and third editions.
Okay.
In jurisprudence.
So in other words, Okay, so I'm saying that Gilbert's is more or less an expounding of the law. And now I'm going to put it back on him to say, can you prove that it isn't?
Well, here's Gilbert's Law Summaries Board of Editors. It reads like Professor of Law, UCLA, Professor of Law, Duke University, Professor of Law, UC Berkeley, University of Texas, Stanford University, Hastings University, University of Texas. These are all guys, and I haven't gone to the second column yet.
Okay, yeah, I understand. Okay,
right law.
Mm-hmm. I mean, but this guy, we're talking about people that, if there's not some kind of a statute, he's going to have everything stricken, which he has.
Yeah.
So if he comes back and he says, "But Your Honor, my opponent has not offered any kind of statutory evidence to his claim."
Well, that's where I got to come up with the evidence to support my claims, and that's the SOIs I've been talking about.
Okay. All right. And so that's actually going to represent some sort of statutory evidence, though.
Well, I'm coming in under equity, not under statutory.
Okay. All right. Okay, and then one of the other audios mentioned UCC1, something about we need to think differently about UCC1 filings under debtor-creditor and UCC filings under trust. Correct. Can you explain a little bit what you mean, how our thinking has to change on that?
Well, it's as simple as the UCC was changed in the year 2000 to reflect that it was no longer used for to create a lien. It was just a notice filing that you need to do your due diligence and search into other facts to see whether or not what we say on this UCC1 is correct.
Okay.
So it just became a notice filing in the year 2000. So it's more different than what we're using in the county. A notice filing contains basically the same kind of information on a one. We're duplicating as a notice filing into the county, although we're not using the UCC1 form itself. So we're just using UCC1 as a record, and we're doing a separate notice into the county as a separate record. So that I can get two records as my two witnesses to prove, which is my SOIs, to prove whatever claim that I'm trying to substantiate.
Okay. All right.
And I need two witnesses to claim a title, because I got to claim it first, and then I need two witnesses to move a title, because once I claim it, I want to move it.
Okay.
So I need two witnesses on the claiming, and I need two witnesses on the moving. And I'm going to use the three, and I'm going to use a county recorder to substantiate the one and the three, creating my two witnesses. So really I'm going to have four records. I'm going to have two records to substantiate my claiming, and then I'm going to have two records to substantiate my moving.
Okay. All right.
I have multiple trust properties. They may have multiple processes and multiple ones and threes in county recordings to move those titles. Also.
Okay. So then the UCC3 then is not just something used for a correction or an amendment. It is now used as a transport or something. To
transfer. It's one of the four methods of formation of a trust. The first one's declaration. The second was transfer.
Right.
Because the assignment on a UCC3 is really under transfers. It subparts down into four. 2A is endorsement, 2B is delivery, and 2C is assignment, and that's the UCC3. And 2D is operational law. So I'm doing an assignment on a UCC3, which is really a transfer, which is the second method of formation of a trust. It's a mechanism that I'm transferring, making a transfer of property, a present transfer into the trustee. And that's when the trust forms, on a present transfer.
Oh, okay. So, but initially or virtually, the one is going to be the same as the three, right? As far as
one is claiming that it's mine, and I got the right to do a three.
Oh, I see.
Assignment or a transfer.
I see. So the one is saying this is mine.
Yeah, because all property is abandoned. All property is abandoned. So I got to claim it first. Got to establish that it's mine.
Okay, so the 1 is the claim, the 3 is the transfer then.
Correct.
Right. Okay, got it. I got it. Okay, good. And then the only other question, and then I'll get off, is this protective order. You were saying that there's really not anything that you can force his hand on the protective order as far as the judge, but it's likely not going to be denied because they know that they need to allow you the protective order. Is that what you're saying? It still leaves some room there for them. If they don't allow it, it's like we really don't know where to go except to say, hey, you got to do this.
Yeah, the protective order is what establishes CCI or trade secret information.
Right, right. And that protective order, did you say there was an example of that somewhere that, or I think you made a reference
under
to where we...
rules under 1.280C7 under Florida Rules of Court.
Okay, 280, what is it again?
1.280 C.
1.280.
C is in cat.
C,
7.
I'm sorry, yeah, you broke up again.
C7.
C7. Yeah. Yeah, by the way, if you're on their desert, there's like a gating device or something like that. That seems to be cutting out like every other few words. But anyway, okay, well, I got 1.280 C, and then I missed what?
Number 7.
Okay, C7. All right.
Correct.
Okay. All right, good, got it. And that's on that'll explain more on the protective order then, right?
Yeah, because that's what you need to establish CCI information or trade secret information. That's the reason that you need the in-camera hearing, because it's private secret.
Right, right. And that will also keep my affidavit of obligation, commercial lien, that'll keep it private. Doing all this is still going to keep that on the private side, I imagine, right?
Yes, because you have a protective order establishing it all to be private information. It's CCI information, confidential.
Okay. Well, what if the opponent, and again, this is just all, conjecture, it's just all theoretical, but if the opponent says, well, that's fine with me, it can stay on the public side or private side because there ain't going to be any collection done on it if it stays on that side.
Well, that's fine.
How would you respond?
Get in the chamber and let's talk about that.
Oh, well, okay. All right. I hope whatever we talk about will eventually get that thing paid. But
the judge has these rope off, and that's when you're in equity, and that's when the trust is operating right in equity, and now you're the 900-pound gorilla.
Okay. All right, got it. All right. Well, thanks so much, Christian. I appreciate all your work, and I can vouch for the fact when you talk about all the study hours that you put in. I know that you do. I get tired thinking about it, but I'm catching up. Okay. Thanks so much for all your help, and greet Lisa for me too. Okay.
Okay. We'll talk tomorrow. All right.
Yeah. Okay. Good. Thanks a lot.
All right.
All right. Good night.
Thanks for stopping by, Charlie. Bye.
Here's a definition of state secret. State secret, out of Black's Law 8th edition, a governmental matter that would be treated, which would be a threat to the national defense or diplomatic interest of the United States if revealed. You are a diplomat. You're an ambassador of a foreign country. The United States cannot let this get out into the public because of diplomatic interests going on. Information possessed by the government and of a military or diplomatic nature, again, the disclosure of which would be contrary to public interest. They don't want this stuff out, ladies and gentlemen. They don't want your CCI, your trade secret information out. So state secrets are privileged from the disclosure by a witness in an ordinary judicial proceeding. Also see executive privilege. You see, this CCI trade secret information, this is state secret information that's going to affect public policy. It is of a diplomatic nature, and it needs to be protected because it's on the private side. It's foreign, because all real people, all we the people, are foreign jurisdiction to the United States. We're all diplomats. We're all ambassadors. That's why we need the protective order. because the protective order establishes the fact that it is secret, trade secret information. And that was where you call the revealing of it in chambers, in an in-camera hearing. So I hope that explains it a little more. So I guess let's close up shop here.
Christian, we got a few more questions. I don't mind spending a little more time with them if you want to do them.
All right, let me make an announcement here again, and we'll maybe do another. About the Moving Titles and Commerce Workshop that's been formally announced tonight as the remedy through NTT, New Trust Technology. And if anybody's new to just came on the call, that this is the formal announcement of that workshop. And you need to go to my website, which is movingtitles.com, and all the information is on there. You can request a registration form. The email address is nttregistration@movingtitles.com. That is also on the website. And my email address to send me email is christian@movingtitles.com. That is also on the website. And the price for the workshop is $299 per workshop, or you can get 2 successive workshops and you save $100. So if you want to take continuing on. But it's all explained on the website, and the website again is movingtitles.com. So check it out there. Okay.
Okay. Christian, we got Michael 613. In regards to the workshops, you are going to have 20 different workshops, each being $299, right? How many maybe that was supposed to be? How many workshops must you take to complete the process? Do we have to attend all 20? And then his follow-up is, I just need to know how much it will cost. His web page is not clear yet in regard to cost. Could you have this?
Okay, there's only one workshop at a time as far as I know. I got room for 150 people, but the workshop is for 20 hours total. It meets twice a week for 2 hours, so that's 4 hours a week, and it runs for 5 weeks. So that's 4 hours a week times 5 weeks. That's 20 hours total for $299. Now, you're the one that's got to decide whether or not you need to go to a second workshop where we'll pick up on, say, like, this will be like course 101, and then we'll go to course 202. So we'll pick up at another one, because I'm sure not everybody's going to be in the same class or learning speed, and they might have to say we have a basic workshop, and then later on we'll intermediary workshop, and we'll have an advanced workshop, so we can continue on. So I hope that answers it.
And then, right, and Mike Malone out there in East Liverpool, England, says, thanks. I was just told over the phone that my bill will be fine for value and settlement. And then they gave me the appropriate address to send it to. No paperwork, etc. has been sorted at this point, although, of course, I have immediately sent the bill off. As soon as I get confirmation that the bill is settled, then I'll be happy. They never even asked for the legal name, security questions when I called the second time. Trust or public debtor creditor, although I spoke total trust. I'm happy camper. It's all good. Laughing out loud. Trust me, they could have been humoring him too, right, Kristen? I mean, is that possible? Right,
happy if they get a remedy.
Yeah, well, keep us posted, Mike. We want to hear the outcome of all that. Okay, let's go to, we got Pete, by grantor beneficiary. I love these Skype names these people have. Hi, Pete here. I got an offer order from the court, and now I want to know how should I go about learning what could be done in the situation. It probably got away from me for now, but for propriety or for prosperity, what action would make them stand up and listen? I did send them a notice that there are privately held docs and a UCC. I UCC'd it and sent it to a notary for witnessing, documenting my written record. What's worse is they acted on a contract that had expired in 2007. I think I would need a mountain of docs to get through this, but I don't think I have enough about me at the moment. Can I come back another time because the case is still open? Thanks.
Well, it sounds like they're trying to attack you under the debtor-creditor relationship, and you're playing that game also. I would come in claiming the trust, prove a trust. That'd be step one: express it and prove it, and then I would create the title to the property, make the claim, move and merge the titles. Either take the trustee and force him in under equity, under trust to do his duty, or terminate the trust, and now he's got to disperse the funds. And number three would be collect on the disbursement, either way that I played it. So it really comes down to that.
Okay, he said thank you. Mm-hmm. Let's go to another caller. It's anonymous out there in cyberland. I know I'm looking for Sister Solja because she Skyped me that she's hanging on, and I don't know what number she has, so we'll go with this one. Let's try to keep it quick, everyone, because we're running into our other programming time. And thank you. State your first name. Where are you calling from, caller?
Albert from Texas.
Go ahead. Robert from Texas?
Yeah.
Albert. Go ahead, Albert.
How you guys doing, Owl and Christian?
Hi, Albert. Yeah.
Yeah. Hit your six about 4 times.
Hit 6?
Yeah. Boost it up. Just do that naturally, everybody, when you know you're coming on. For some reason, everybody's usually low.
Oh. Can you hear me now?
Number 6. Just
6.
Hit 6 again. 6. All right, that's better. Go ahead.
Okay. Christian, you've spoken a lot about the rules of signatures, but my question deals with this, but it's on the other side. What would be official to do a trust? What is the rules of signatures say on the opposing party?
Okay, you're kind of breaking up there. I'll over-modulate in a way a little bit, then I can't quite catch what you mean there. Could you kind of like go over it again?
All right. Can you hear me now, Christian?
Yeah, go ahead.
Okay. The rules of signatures, how does it apply to the opposing party?
The opposing party. I really don't care how it applies to them. It's going to apply to them because I can be able to prove trust through the signature, and then that's going to get me into equity, and that's where I want to be to really have the upper hand. Because if he's the trustee, then the burden of proof, the onus probandi, shifts upon the trustee, and he's assumed to be guilty. And now he has to come up with a record that he made a payment, or else he's presumed to be guilty that he didn't already. The only way he can win is on a record of a payment.
So in documents that you may receive from whoever you're dealing with, if they have no signature, it doesn't matter?
Well, yeah, it doesn't really, not so much that it doesn't have a signature. I can always create evidence that's needed to prove a trust, just by the UCC ones and the county recording notices. Because those are the two records that proves that, I was, say, the signer on the documents or the instrument, say the promissory note or something. As long as I can prove that where it all starts from, then I've got that material fact, that SOI, to support my claim. And my claim would be that it's a trust. And that's the whole starting point right there.
So if you get a letterhead, that's good enough.
Well, it's not just a letterhead. You need to create a public record of that letterhead or that document that was sent to you as the offer, or the record of my payment. You need to create a record. I need a UCC1 filing, and I need a county recorder. I need certified copies of that. There's my two witnesses to prove that because that's a public record. It is outside the hearsay rules because it's rules of evidence. Rule 902 in federal says that it's a self-authenticating document, the notary public, and anything out of a public record can't be hearsay. So I'm creating evidence. Public records.
Okay, see, basically my question was if you get documents from whoever you're dealing with, and they're not signed, it doesn't matter. You can still form a trust.
True. Right. My intent.
Okay.
What is my intent and purpose? All I have to do is put it in writing and record it. That's my manifestation of my intent and purpose. So if I did a declaration and got it on a UCC1 and county recorded it, pulled out certified copies of those, my 2 witnesses there of my declaration, that is a manifestation, a physical record, a manifestation of my intent and purpose.
Well, thank you, Christian. I've been hitting my head a lot with this stuff, and I've been trying to get a signature from the opposing party, so now I know I don't need one.
Oh, I don't need it.
So thank you very much.
No. I need I can create the intent and purpose just by recording documents. It's exactly how they're getting you. Because if you stop and think about it, because we went over this on one of the other shows, on one of the other, where we talked about intent. What was intent? I went into one of the last shows about 2 weeks ago. I think I went over intent pretty thoroughly. Where I talked about sentient knowledge being on the private, but they don't have to have sentient knowledge on the public. And how they prove it on the public side is that they create a record, and the record is supposed to be the proof that you knew or you understood even when you really didn't have sentient knowledge and didn't know and understand. But it's the record that proves. So I'm going to use that way that they're functioning on that public side the same way. And I'm going to get them that way. Because I'm going to use it against them. I'm using the very same tool and method that they're using to get me, reversing it and using it against them and forming a trust. And when we got a trust, I proved the trust. Now I'm in a court of equity in chambers, and that equity is assuming from the get-go that that trustee didn't make a payment and he is guilty. And that's exactly how they treat you under admiralty, as bringing a breach of the trust, where they slide you into equity for the enforcement, then back out into the penal sum and get you for that. So I'm using the same tools, but maybe it's because I understand it more, but how I've been studying for so long that I can see it and how to manipulate it and work it to my use. And combining that with trust, because really the NTT trust end of it sits on moving titles platform. And the moving titles platform is just a way of creating evidence of anything I want to do. So I can go in preparation to go into court to prove my claim.
Well, thank you, Christian.
Okay, thank you. One more question, Christian, then we're going to wrap it up. Mr. Soldier, you're not raising your hand out there because you just shared your number with me and you're not anywhere to be found. So just take note of that. Now, her question is this: how do I clear up my portion of the national debt, war debt? How do I repair my standing on the 1040 and the IRS master file?
Well, those are tall questions there. I mean, we could do a show just on each one. Basically, I really don't care what the amount is. I'm going to give, say, like a bill of exchange, and what a bill of exchange is I'm taking 2 separate bills, and we're going to exchange them as payment. So I'm going to give you a bill of exchange authorizing you to take any amount out of the account, out of the trust funds, and apply it to the public debt that is owed, that is my share, say. That's basically what we're going to do for the, and also for our present debt, past and present debt. And now the individual master file, to correct that in the IRS, I'm going to do a Treasury Directive hearing on 25-06. and I'm going to have the commissioner submit the information to the commissioner to prove my standing as, say, changing it from trustee to beneficiary. Now, all the records under the U.S. Attorney's Manual under 6-4.010 says that the IRS records, all other agencies must comport to that. Now, if I corrected that individual master file, all other agencies must match that master file now. And if I just set up myself as beneficiary, then I can go ahead and all the other agents are going to comport to that.
All right, that's anonymous. State your first name. Where are you calling from?
Oh, that was me, Sister Soldier.
There you were, hiding out all the time. See?
Yeah.
Okay. You have a follow-up then?
Well, I just wanted to thank him for that response. I know I'm going to have to probably, when I take the class, I'll need more detail on that last question on the master file.
I mean, that was just a model answer, you know. But if you understand the model, that gives you a basic idea of how we're going to get from point A to point B. And now we got to fill in all the details between that.
It does. And I was listening to one of your calls. Do you suggest that we express the trust with the treasurer on the birth certificate before we do the SS5? Because that makes so much sense. Are we sending it to the wrong person, sending it to Paulson, Snow, and Geithner, and they're dealing on the bankruptcy side, when the treasurer holds all the assets, and that's who we should have been sending our birth certificate to, accepted for value all along.
Yeah, we should have been the private side, which was not Geithner, say, or Snow or Paulson. That was the debt side.
Right. And so the birth certificate will be the actual special deposit. Are we putting a dollar amount on that?
No, not yet. Although we could, but you know, that's unlimited funds. I could always go back and make another special deposit of another known amount.
Okay, so the first deposit should be blank.
Yeah, that would more or less of a claiming. Like claiming the title.
And in that notice to the treasurer, could we tell the treasurer to take out any money that's owed for past, present, or future debt? Would she be capable of doing that with the deposit from the birth certificate? Can we just nip it in the bud right there?
Yeah, you're thinking Treasury, but you know, I'm thinking Treasury, IRS, right hand, left hand, although the same entity.
Yeah, I'm thinking treasurer, like you said on the other call. What's her name? Anna
Rio. Yeah, Anna Escobedo Cabral was the other one. Now she's successor is now Rio.
Oh, okay. So couldn't she be able to take out the debt that we owe from the war debt and all of this, so we won't be considered, you know, enemies, trading with the enemies and all that?
Yeah, but she's the one probably that's in charge of it, but trouble is it's probably going to be sent to the IRS part of it, and some flunky under the private side is going to do the set-off.
Well, but she would do that, or would we send it to the flunky on the private side of the IRS?
It could be if we know exactly where it is. We could send it directly.
Or give her the fiduciary responsibility to do it, you know, since we've given our permission for it to be done.
Right, that's all it is. I need to command, direct, and order.
I love it.
First establish,
okay, thank you very much, Chris.
Direct, and order.